In today's video, we're going to talk about 3 different cases against LVNV funding for Fair Debt Collection Practices Act violations, where they lost these 3 lawsuits. And I'm going to talk specifically about the violation in the FDCPA that made them lose the cases. And all of these cases, they will not be able to appeal or go back and have a different ruling, because they were clear violations according to the Fair Debt Collection Practices Act. And what I want you to do right now is I want you to like this video, because I'm going to help you with the information in this video about how to combat any debt collections that you have with any debt collector, and especially with LVNV funding, using the information from these 3 lawsuits that I'm going to talk about. And also, by you liking this video, you are actually helping other people get exposed to this information to be able to help themselves, just like I'm helping you. Now, I understand that you are frustrated. You got debt collection letters coming at you. Maybe they're suing you in court. You don't know what to do. You want stuff to get back to normal. You don't want to be worried about this stuff. Maybe you got those debt collection letters and you put it in the back, somewhere, and you just thought, hey, if I put it in this drawer, nothing's going to happen. And I'm here to tell you that stuff does happen. But I do understand your reasoning behind that thought process. If you put it in that drawer, you don't do anything with it. Maybe you don't open the envelope, maybe you throw it away, and you think that all of this stuff goes away, but it doesn't go away. And I understand that you want to learn, but the problem right now is that there's a lot of people that are out there giving you inaccurate information when it comes to dealing with debt collectors. Inaccurate information on how to fight back against debt collectors. Not to say all of them, but a lot of them are giving you information and putting you in a bad position. We're not about that. Just in case you don't know who I am, my name is Stephen A. Williams. I'm the president and founder of the creditrepairshop.com. I help busy people repair their credit, increase their scores, and get out of debt. That's my main goal of my company. That's the mission of my company. And I've been helping individuals and families and business owners since 2006 with their credit, debt, and increasing their scores. So now let's hop right into it. The first case that we're going to talk about is Leah White versus LVNV funding. And these are 2024 cases. These are recent cases, 2024. The plaintiff, Leah White, accused LVNV funding of violating the Fair Debt Collection Practices Act provisions by contacting her through inconvenient means, despite White's request to be contacted through via email. LVNV funding sent her certified mail letter to collect a debt, which she claimed violated 15 U.S.C. 1692 A1, which prohibits debt collectors from communicating with consumers at inconvenient times or places without prior consent. Now, when you have a right under the Fair Debt Collections Practices Act to have debt collectors cease and desist all communications. Now, this is something that they could do, and they can continue moving forward with what they're going to do if they want to try to sue you in court. You also have a right under the Fair Debt Collection Practices Act to tell them how you want them to communicate with you. Because if you do not do that, they could try to communicate with you all different type of ways. Let me give you some examples. Calling references. In those applications that you filled out for credit, any of those references that you put in there, they'll call. They won't say that they're trying to collect on a debt with that reference. They'll say, hey, this is such and such. I'm trying to contact John. You happen to know where he's at? Or, people have had their neighbors come to them and knock on the door and be like, hey, this company called and they're looking for you. We're like, what the hell? What company? LVNV funding. Everybody know who LVNV funding is if they ever had an issue with debt collector. But they are allowed to do that unless you specify to them in writing you do not want them to contact you that way. You do not want them calling your references on the application. You do not want them calling you on the phone. You do not want them calling you at your job. You do not want them contacting you on social media. You have to point that out in your cease and desist letter. You could say, communicate with me by email. That is the only way that you can communicate with me. And that is a very good way, either in writing or by email. The reason why is because that way you can have a paper trail, quote unquote, digital trail of what they said and what you said back to them. So it'll help you if it gets into either where they're trying to sue you in court, or if they're trying to make certain claims and they contradict the claims that they made in the email. You want this in writing, because if you're doing it by phone, it's going to make it very difficult for you to prove any inconsistencies that could potentially come up in the future. So, Fair Debt Collection Practices Act 15 USC 169 to C as in Charlie, A as in Apple, 1. Look for that paragraph. You'll see that they cannot communicate with you in any convenient times or places without prior consent. Also, when it goes to emails, they cannot send any email to if you have a business email, like you work for a company email, they cannot send information to that unless you use that email on a personal level. So if you use your company email to also receive personal information, I don't know how they know that, but that's the only way that they're able to utilize your company email, is if you use it for personal information. All right, so let's move to the next one. This was an actual class action lawsuit against LVMV Funding and Resurgent Capital Services. Now, Resurgent Capital Services is the bridge that LVMV Funding uses to purchase the debt. You could say, if you want to visualize this, LVMV Funding is the lineman. If you got a football team, they're the lineman, they're the center. Resurgent Capital is the quarterback. They're the ones that's doing everything. They don't want them to get hurt. They don't want them to get touched. They want LVMV Funding to do all of the dirty work. But in this CFPV class action lawsuit, they went after both LVMV Funding and Resurgent Capital Services, because the CFPV can find out who is doing what, where, when, and how when they do their investigation. So it says, in this case, plaintiff alleges that LVMV Funding and Resurgent Capital misrepresented the nature and the character of debts in Chapter 13 bankruptcy proceedings. The court found that these false representations constituted a violation of the Fair Debt Collection Practices Act, prohibited against false, misleading, and deceptive practices. Now, you have to look at the Fair Debt Collection Practices Act to understand, because when they say false, what does false mean? Misleading, what does misleading mean? Deceptive, what does deceptive mean when they say false, misleading, deceptive practice? Now, let me tell you from my experience what false would mean, misleading, and deceptive, from what I've seen when it came to dealing with these companies and other debt collection companies. False would be false documents. It could be false documents, it could be false statements, it could be things that they say to you either over the phone or information that they send to you, and that information is not true. Like plain and simple information is not true. You're going to have to review the information. You're going to have to recollect your memory. You're going to have to look at your specific debt collection issues that you're going through to try to figure out, is this information false? Like, are they really making things up and presenting that information to you? The next thing is misleading. The information that they give you is misleading. This is where I've seen misleading happen. When they were suing people in court for debt collections, I've seen documents where it made it look like the information that they were presenting to the court and presenting to the defendant who they allegedly owed the debt, was that they would produce these affidavit documents. And when you look at that affidavit document, if you did not read through it, if you just looked at it for what it was, by what the word affidavit means to us consciously, it means that someone has sworn to a document. So some people, when they see the word affidavit and they look at a document, they won't even review what's in that document. because just on a legal conscious level, you in the sworn, someone swearing to it, you can read the first sentences, it can make you believe that everything in that document is true because someone has sworn to that document. But actually what that document is doing, and what I've experienced with reviewing these documents, it is a form of misleading the court, because many of the things that they swear in those documents are only swearing to the documents that they have, but they make it look with the impression of that affidavit as if they worked for the original creditor. None of the documents that they're reviewing and that they're receiving have been sent. That individual who is swearing in that affidavit has not sat down with the accounting department of that original creditor and went line by line with the information that they're receiving about the alleged debt that they're trying to sue someone for. And in those, in affirmative defenses, those documents have been torn apart, because when you simply state that they're only swearing to the documents that they have in hand, and that none of those documents have been authenticated by anyone with the original creditor, it blows that whole document apart. And that is considered misleading the court. But if no one reads through it, but if no one breaks down in an affirmative defense why that document really does not hold any weight, it just gets to pass through. Now, in this specific case, I don't know, with this one, it was mainly focused on what they were stating for bankruptcies. I'm telling you what I've seen on how they utilize those documents. Now, deceptive practices, doing things to make people feel a certain way when they receive the information about a debt collection that's coming after them. That's the way that I would describe it. So let's just say that you receive a letter in the mail from a debt collector, and then you receive other information from the debt collector that contradicts what you received in that letter in the mail. Maybe you were talking on the phone and they said something entirely different. Maybe you received that information in that letter, and then they did not notify you that debt was time barred. And with that debt being time barred, that you don't have to pay that debt legally. This is considered deceptive practices because they're not notifying you about your rights. Maybe the mini Miranda rights. A lot of people don't know that you have a mini Miranda rights, that they have to tell you that this is an attempted to collect a debt, and any information that they're utilizing in the attempt to collect the debt can be used against you trying to collect on that debt. So if they don't notify you, they are deceptively using deceptive practices to attempt to collect that debt from you. They're not notifying you of your rights. They're not notifying you that the information that you tell them could be used against you. Just like I said earlier, the information that you give them, even if they don't have that information, they're going to be trying to go out and talk to you or try to get information about you, information about what you're doing to be able to collect on that debt. And some of the times they can violate your rights when they're trying to get that information. So now let's go to the next one. It was Christie versus LVNV Funding. In this case, Christie claimed that LVNV Funding repeatedly contacted her directly despite knowing that she was represented by an attorney, which violates the Fair Debt Collection Practices Act. Furthermore, LVNV Funding was accused of operating without a valid collection services license in the state of Tennessee at the time that they were trying to attempt to collect the debt, which is both federal and which is a violation of both federal and state laws. Now, I can tell you that all states do not require debt collectors to have a license to collect debt in their state. There are some states that don't have that, do not require that. In my state of Wisconsin, they do require it. So that's one of the things that you can look for to see if they are even allowed to contact you without a license in your state. Now, the other thing to talk about, representation of an attorney or someone who has a power of attorney over your to talk to the debt collection company about that debt that you're work that's being worked on for you. We go through this a lot, not this problem a lot, because mostly debt collection companies, when you send over that POA, they're going to talk to the person that you either put in place or hired to contact about that debt. They're not going to usually violate that. So this is something that I had not ever ran into before, or maybe one time, maybe potentially. But this is a violation, because if you give them a power of attorney, or you have someone in place, of an attorney in place, they are not supposed to contact you directly. That would be a violation, because just like we talked about in the earlier one, where they have to speak to you according to 15 USC 169(2), C as in Charlie, A as in Apple 1. They have to communicate with you the way that you authorize them to communicate with you. And partly, one way could be through an attorney. Don't contact me, I have this attorney handling it. Or a company like the Credit Repair Shop, where you have a power of attorney on file and they have to contact you through the Credit Repair Shop. Now, let me talk about the benefits of that. The benefits of that. One of the things that I've seen where when this kind of goes into what the class action was about, is that you could say things that could be used against you, and it's like that goes into the false, misleading, and deceptive practices. One of the techniques, strategies, tools that debt collection companies train their representatives with, and you've probably experienced this when dealing with a debt collector, is they try to get you emotional. They try to get you talking. This is what they want to do. They don't let how much that information that they're getting you to talk about can work against you, with either not having to pay that debt because of certain violations, or getting you into a very good position to settle that debt, or potentially having that debt forgiven through them, and if it's with the original creditor, forgiven and sent through with a 1099-C to the IRS, because you can end up saying things the wrong way, saying things, people don't always want to make themselves look bad. When it's not making yourself look bad, when you're just telling the truth about your financial situation, or maybe you have some medical stuff that was going on in your life that made you not be able to pay that debt. People are going to always want to make themselves look either all the way down and depressed, or somewhere in the middle, or somewhere high. But when all three of them could make your situation worse when you're dealing with debt collectors. I'm here to tell you that when you're dealing with debt collectors, the number one thing that you have to do is you got to feel them out. You got to get the options on the table from them. And then you proceed with giving information about your situation. That's the way that we do it. I believe that that's the best practices, and any attorney that is working on your behalf with debt collectors would do it that way. And that's definitely the way that we do it with the Credit Repair Shop. All right, so I gave you some good information for you to be able to move forward with fighting debt collectors. Look at your documents, rewind this video, watch it again, so you can see some of the Fair Debt Collection Practices Act violations that could potentially be that you could be dealing with either a debt collector who is just sending letters to you or contacting you by phone, or if you have a lawsuit that you're dealing with a debt collector. If you need help with your credit, please visit us at creditrepairshop.com. Watch the video, What Makes Us Different, so you can see my 8-point validation process, my 2-phase settlement process. If you need your credit reports and scores, go to the website your3scores.com to grab your TransUnion, Equifax, Experian credit reports and all 3 scores. If you have debt collectors coming after you early in the game, grab my 3-pack of letters, statute of limitations, debt validation, cease and desist, collection activities letter. I do ask for a donation on those. It helps me monetize my time, the time that I help you with these videos, and also those letters can save you time, money, and frustration. If you have debt collectors coming after you, suing you in court, I have a service for that. Go to my website, creditrepairshop.com. In the live chat, tell us what's going on. Upload the summons for review. We'll let you know how we can help you. If you have debt collectors that are just sending you letters, you can use my 3-pack letters, or you can have us create a certified letter for you using our expertise. links are below. Go to my website, go to the payment page. You'll see that service that's available. If you need something more extensive, go to the live chat, put in what you're going through, and then we'll follow up with you to let you know how we can help. Thank you for your time. Subscribe to the channel. Post your questions and comments. This is Stephen A. Williams, President and Founder of thecreditrepairshop.com.